So without further ado, Martin Ozinski.
All right, well, hello everyone. I'm very happy to be here. I'm going to talk to you a little bit about I'm going to be focusing on the law of environmental harm, the legal aspects and the legal issues that are raised, and that I hope will start to be developed with more rigor going forward. Ever since everyone's been talking about United Keno Hill mines, it is the paradigm sort of case for sentencing in Canada. And you get the impression, I think most of us would agree, that this impression of a relatively stable and predictable list of factors that are going to be considered when we're considering the quantum of the sentence that should be imposed. But in at least one aspect, I think that stability is misleading, and I'm referring here to the quantification of environmental harm. As recently was observed in R versus Northwest Territories Corporation, a case that our former speaker, John Cliff, one of the hundreds of cases that he's been involved in and that we've been discussing over the last 2 days, the court there said that the difficulty of proving an ascertainable and quantifiable harm is present in most environmental cases. And I think that that's certainly true if you look at the jurisprudence where that task has been undertaken. It does seem to create some problems. And so my goal here today is essentially to familiarize you with some of the legal dimensions, and Peter will speak to the economic sort of tools that are applicable, of a relatively tried and tested approach actually to quantifying environmental values and environmental harm that has never actually been successfully applied in the environmental sentencing context. I'm talking about environmental valuation, which is essentially just the monetization essentially of things that we care about, the natural world, right? And there's maybe that in and of itself maybe raises some ethical issues. Luckily, I'm not going to deal with those sort of ethical, philosophical issues because, as I will show, that question has essentially been decided by Parliament, and in fact in the context of the Environmental Enforcement Act, which we've been talking about throughout the last 2 days. So I'll begin by first giving a bit of a history of environmental valuation. I'm not going to get into the details again. Peter's going to focus on the economic aspects in detail, but I did want to just provide a bit of a snapshot to sort of give you a sense of what's at stake here, what are we talking about. And then I'll jump into the legal framework that's going to be applicable in this context in Canada. And what we'll see is that in addition to the changes that Rebecca talked about under the EEA, one of those changes is this introduction of these economic terms, use value and non-use value, in the definition of environmental damage in those sentencing provisions of 9 federal environmental statutes. I then want to take a little bit, sort of step back and look at some of the common law that's been sort of developing up until this point that will inform, I think, the interpretation of those principles. And what we find here is that in contrast to the civil liability context, where really it's only actual harm that matters, we're trying to quantify how much harm has occurred so that we can compensate the injured party. Restitution is sort of the guiding principle. We'll see that in sentencing, there are actually several kinds of harm that matter. And then I also want to talk a bit about the burden of proof. So a brief history of environmental valuation. So some of the earliest stuff that we actually saw was around the 1950s in the United States, where there, at the time, entrance into the national parks, for instance, was free. But there was some desire by park managers to have a sense of, well, what are these parks worth? And so they asked some economists, and one economist told them to get lost. But another one said, well, okay, maybe we can actually do some work here. And I talk a bit about the methods there, and Peter will talk more about those in detail. But as is often the case, I think, in environmental law and environmental policy, it usually takes a crisis or a major catastrophe to really get the ball rolling. And so it was with environmental valuation, I think, which was really spurred both in the methodological context, but also in terms of legal context, by the Exxon Valdez spill in the United States in 1989 or 90, which really brought forward some of the methodologies that Peter's going to be talking about, contingent valuation. We had changes on the legislative scheme in the United States, the passage of the Oil Pollution Act. So that really drove a lot of these developments, a lot of the tools. There was a study that assessed, and we'll talk about these terms later, but the passive use values associated with the Prince William Sound, that's where the Exxon Valdez happened, and it estimated that the loss of those values was around minimum $2.8 billion. Since then, another development, which I think, if we were looking at a graph over time and we sort of see these bumps in activity, is the emergence of this ecosystem services paradigm, right? The idea that the nature and the environment can be analogized to a form of capital, natural capital, that gives rise to various services, so whether it's water filtration, flood mitigation, habitat provision, these kinds of things. So this kind of approach and paradigm for considering and conceptualizing in the environment also relies heavily in terms of translating those services into monetary figures, relies on traditional economic tools that are used in the context of environmental valuation. So we see another bump there. And so, for instance, in Canada, we are starting to see some work. It's been sort of slow in going, but in the last 4 years, 5 years certainly, we've seen some significant studies of varying degrees of rigor. And again, Peter will speak to that issue, the issue of methodological rigor. But for instance, so the boreal forest, the Mackenzie region of the Northwest Territories estimated $570 billion in ecosystem service values per year. One study that Peter was involved in, the fourth one here on my list, the marine mammals. This was commissioned by the Department of Fisheries and Oceans, $962 million per year in terms of environmental values. So the polar bear, for instance, this was a study done a few years ago. There was sort of a question of what is the economic value of the polar bear to Canada? And again, here you see a massive number, $6 billion per year. And this is primarily in the form of what we refer to as non-use or passive values. And we'll talk a bit about those in a second. So let's come back to the Environmental Enforcement Act. I don't remember, Rebecca, if you had the list of the statutes that it amends. Okay, you did, so this is repetitive. I put one small gloss on this. So the statutes that I've listed here in red, these are the primary sort of environmental law workhorses. When you go, and if you look at, for instance, the website, there was some reference to Environment Canada's websites or various enforcement agencies' websites where they publish some of the offenses and prosecutions that they're doing. When you go on the Environment Canada's enforcement notifications website, you see that the SEPA, the Migratory Birds Convention Act, and the WAPREDA, of the statutes amended by the Environmental Enforcement Act, these are the ones that are doing most of the heavy lifting. I'm about to talk about one case in the Canada National Parks Act, but that's really an outlier. Of course, in addition to these, probably the other mainstay in the federal family is the Federal Fisheries Act. And it has been amended recently to include the higher fine regime, but it does not include the sentencing provisions that I'm going to be discussing in the next few slides. So R versus Decker is actually, if you believe the judge who wrote the decision, it might be the first reported decision under the Canada National Parks Act, first reported offense. And the CNPA, the Canada National Parks Act, is one of the statutes that was amended by the Environmental Enforcement Act. And so in that case, the judge does, and so this is one decision where this new scheme, the provisions that Rebecca was talking about, is sort of set out by the judge in the decision. And so the judge notes that section 27.6 sort of codifies this idea that the purpose of sentencing is deterrence, denunciation, and restoration. And then it goes on at 27.7 sub 2 to list a series of aggravating factors. And it's really the first few factors that are relevant to my discussion here today. So whether the offense caused damage or risk of damage to park resources, whether that damage or risk of damage was to any unique, rare, or particularly important or vulnerable park resources, and whether it's extensive, persistent, or irreparable. And then it goes on to list a series of other things, which are essentially, with some embellishment and some flourish, they are essentially a codification, I think, of the United Keno Hill factors. But then it goes on at the very end to define or to indicate that damage, for the purposes of these, A through C, includes loss of use and non-use values. So what are we talking about? What's the big deal? So it turns out actually that we could go to economics textbooks to learn about what these terms are, but in fact we don't have to, and that's useful for us as lawyers because I think we don't like to go outside too often. We can look to the Supreme Court, actually, and we can look to a decision which maybe I'll admit I'm starting to get a little tired talking about, if only because it was at the time, 10 years ago, sort of considered to be this watershed moment in environmental law. It opened the door to sort of common law environmental damages, and yet I don't think there is, to this day, a single reported decision that it sort of picks up where Canfor left off. But in any event, here we have it in the civil liability context, the Supreme Court's decision in Canadian Forest Products versus British Columbia. And so that case involved a forest fire. The company, Canfor, was negligent. They sort of admitted to being negligent. And the question was whether or not, in addition to the sort of loss of revenue associated with the commercial timber in that case, whether the Crown was entitled to claim environmental damages for those areas of the tenure area that were actually set aside for what you might call environmental reasons, and this might be because they were riparian habitat or whatever it is, that they were in a certain area. And the court basically said, yes, we would be amenable to that kind of damage claim. We don't see any reason why the Crown, the province of British Columbia, should not be able to sue, not just for the, for those commercial value, but also for these environmental values. And it went on to explain and describe what some of these values are. So for instance, use value includes the services provided by ecosystems to humans, and includes water quality and recreational opportunities. And the court went on to acknowledge that even if we're not charged for some of these things, it is possible to quantify them economically by observing what we might pay for comparable services on the market, right, in the free market. The court went on to acknowledge that there are also passive use or existence values, and that these are values that essentially derive not from our use of any particular natural resource or environmental asset, but simply from its mere existence, right? So the idea that you know that the polar bears exist, and that you might further be satisfied and take some kind of sort of happiness from knowing that your children might someday know that polar bears exist or that whales exist or what have you. And these too can be quantified, although it does get a little bit harder. And again, this is what Peter will be talking about. One sort of famous sort of methods, and that was certainly subject of the Exxon Valdez bill, is this idea of contingent valuation. So essentially a stated preference technique. You ask people essentially with carefully crafted questions how much value they would place on a given ecosystem asset. And the problem with Canfor, of course, was that while the Crown wanted to claim these damages, they actually didn't introduce any evidence of these losses. They didn't do any of the hard work. And you'll see that that's essentially a theme, I think, that I'm going to be picking up here, and then I think Peter will be picking up on too. So now we know what these values are, and we know that this has now been sort of, this concept has now been transplanted into the sentencing context. But it's important to note then, before continuing and before getting rolling up our sleeves and getting in there, that the analysis is going to differ in at least two important ways. And the first way that is going to differ is in the kind of harm that matters. And so I would suggest that in tort law, where the goal is compensation, so the only thing that matters is to restore the plaintiff, to the position that they were previously. That's it. That's what. So you want to quantify that loss as precisely and accurately as possible. In the sentencing context, actual harm does matter, certainly. But what's clear from the case law, and I get into this, I hope I've convinced you if you read my article, my short paper, I try to sort of trace this, and I've posted some of the major cases here, but it's clear that in sentencing, it's the risk of damage that matters as much, if not more, actually, than the actual damage. And that makes sense if we think about it in a sense that most environmental offenses, yes, they'll involve varying degrees of harm, but they're not usually the big ticket. It's not usually the Exxon Valdez, right? It's not usually massive spills. It's like Syncrude. It's 1,500 ducks, which is certainly not, it's not negligible, but these are not massive, this is not a massive amount of environmental degradation. And so the courts have sort of recognized that, I think, and they said, it's not, if the goal here is prevention, and if the goal is deterrence, and I explain, and there are several cases that set this all out, then we have to also look at the risk of harm. And they seem to go even further. And I would say that in fact, it's not just one kind of risk of harm that matters, but rather there's both what you might call the specific risk and then the general risk. And so with respect to, so I guess backing up a little bit, right? And we'll start with United Kino, because I think that's a good place to start in light of the discussion the last 2 days. So in United Kino, the court said, Justice Stewart said, penalty should reflect the degree of damage inflicted. If the damage is irreparable, extensive, persistent, or has numerous consequential adverse effects, the penalty must be severe. In some instances, not only the actual damage caused but the potential damage that might have emanated from the polluter's activities must be considered. So here we get this idea of specific risk associated with the polluter's activities and the potential that even if the actual harm was not so great, if there's a potential for a greater harm in that specific instance, that the court should consider that. And we see this being picked up in Northwest Territories Corporation, the case that John was involved in. The court sort of cites several other cases which are unfortunately, and this is another theme I think from this conference, unreported, but somehow the judge there got his hands on them. R versus Shamrock, which is a 1989 case. And there the court said, if public welfare offenses are preventative and their purpose is to set high standards, no actual damage should be necessary to attract substantial penalties. The degree of risk or potential harm inherent in the activity should be the primary criterion for substantial penalty. Similarly, in City R versus Iqaluit, there is no evidence in this case that the discharge of sewage in this case resulted in any fish kills. However, the potential for harm to the environment is the potential for harm to the environment that is the gravamen of this offense. Actual damage, where proved, is an aggravating circumstance that would likely elevate the sentence that would otherwise be imposed. And so we see the courts clearly saying, yes, actual damage, but also what about the risk of damage? And then, like I said, I've gone on to separate and or identify two categories of damage, and I think that's clear, especially when you consider the R versus Carrier case. So in Carrier, what we had was essentially poaching, illegal taking of too many birds, migratory birds, in contravention of the applicable regulations under the Migratory Birds Convention Act. And there the court said, look, we're talking about maybe 300, 400 birds. This is not a significant, this is not a huge amount of actual environmental damage. But the court then went on to sort of say, but what if every hunter in North America took more than their legal limit? What would be the impact on migratory birds then? And we see that being picked up in Syncrude, actually, when the court's considering sort of under the context of the due diligence discussion, but I think it would be equally applicable in this context if we actually had a sentencing case. The court sort of says, I'm not just interested in the harm that was caused in this specific incident. I need to turn my mind to the potential impact if every, for instance, oil sands operator was to sort of disregard or not take seriously their bird deterrent responsibilities. So so in my mind anyways, we seem to have three kinds of harm that matter.
Martin, can I just pursue it? There must be some environmental offenses, though, where actual damage is actually an element of the offense,
That's right.
Like maybe the fish habitat provisions.
Right, so that would be the classic distinction between Section 35 of the Fisheries Act and Section 36. So Section 35 requires now, under the new provisions, serious harm to fish, which includes permanent alteration and destruction of fish habitat, where Section 36 focuses on the deposit.
Right.
And you don't need to prove any kind of environmental harm. And so you do get a bit of it is interesting because what essentially it's, in some cases to secure a conviction, you don't need any evidence of harm.
Right.
In some cases you will. And I think it speaks actually to the point that John made, that sometimes the sentencing is an afterthought. And I think certainly it will be an afterthought where the offense itself, the provisions in question don't require any kind of evidence of harm. But where there is some requirement of harm required, then maybe there'll be more, you have a better chance that you'll do more of that heavy lifting in the trial stage, in the conviction stage,
right,
and then be able to carry that over into the sentencing stage. But I think that's absolutely right, yeah, that there is that difference. So then, if we're thinking about environmental valuation, and again, so in terms of actual damages, and there are going to be times, right? So the 1,500 ducks in Syncrude, I can think of countless other cases. We have right now ongoing spills going on in northern Alberta associated with some of the in-situ oil sands mines there. There's going to be actual damage. And I'm going to let Peter talk about that, but what you'll see, I think, is that the issues there are essentially the same as are raised in the tort context. You are just trying to quantify a change in the environment and a change in value, and that raises some problems and some difficulties, especially when you don't have some of the sort of on-the-ground facts beforehand. But the risk of damage, I think, is quite different, right? This is a probabilistic exercise. And although few judges, there's no judgment that I found where it was written quite this way, if you look at some of the sort of leading cases, and they've been discussed already today too, Turocco, for instance, in Turocco, the court says very clearly that the risk of harm is a function of, the kind of product that's being used, its potential for harm, the nature of the environment. When I did some research on this, I think the most common expression of risk, and that's the language here, right? It's damage and risk of damage. The risk is most commonly expressed as a function of the magnitude of harm times the probability of harm, right? And each of those things can be broken down further, but that's the general equation. And if you look at, for instance, most of the recent oil spill related sort of reports and all that kind of stuff, and the discussion in news about oil spills, I mean, that's the general algebra that people are doing. That's the math. What is the potential for a spill times the potential severity of that spill? And so I think in this context, environmental valuation could play a very useful role in terms of quantifying M, the magnitude of the harm, right? So, for instance, if we know that the value of polar bears, what did I say in my previous presentation here? 6 billion per year, right? If someone contravenes a regulation that has some kind of, the Arctic Water Pollution Prevention Act or something like that, and there's some evidence of harm to polar bears, if polar bears, are worth 6 billion, and I'm not an economist, so right now I'm taking some liberties, and again, Peter has some more sort of, I think, probably a little more rigorous methods that could be applied here, but just to my mind, I think to myself, well, if polar bears are worth 6 billion, then even the death of one polar bear can attract a fairly significant fine, right? We're talking about fractions that will bring you into the millions of dollars very quickly. Similarly, I was looking up, for instance, just the regulatory impact analysis statement for the recent wastewater system effluent regulations, right? So these are the new regulations under the Fisheries Act. And in the cost-benefit statement under those regulations, they say that, yes, these will impose a fair cost, $5.9 billion probably on municipalities in terms of capital investment and all that kind of stuff. But the overall quantified benefits of the cleaner water that will be the result of these regulations is estimated at minimum $17.6 billion. So that's the benefit that compliance with, at the setting up of this regulatory scheme, and that's based on some of the techniques that Peter's going to talk about. So then, for instance, if someone violates, if we have an offense under the WSER, and the court is looking at the general risk that's posed by that offense, I think 17.6 billion is a good benchmark to start with, right? Because one of the problems, and I maybe haven't said that yet already, well, I did say that this is a hard area, right? Judges are constantly sort of like how do we put a price here? And one of the things that they do actually, and it probably doesn't happen that often, and I think that's reflects what the speaker said earlier, but they do kind of rely on parity. They scrap and scrounge for cases that give them some kind of idea of like, okay, well, what's, this farmer did this, so, and their penalty was this, so how does that apply here, for instance, the context of deposits of pesticides? So that, and then to my mind, that's just, if you get the first one wrong, then it's not a very useful benchmark for parity. But if we have these figures and we start bringing them in, and we're seeing these figures being, this kind of analysis being done more and more, I think that this is evidence that should be introduced and should be put before judges when they're assessing the risk of damage, to give them a quantifiable benchmark against which they can then move the penalty. And so we can do this, whether if it's an offense in the national park. Now the R versus Decker case, I said that was an offense in the national park. In that case, the court just kind of flew over the damages provisions. She said there was no evidence of any damage in this case, but at the same time, the court cited another case where there was clearly significant damage done by ATV vehicles and off-road vehicles. And so, for instance, if we know that Banff National Park generates X amount of revenue on a yearly basis based on tourism and all that kind of stuff, well, then we start to have some figures, something to play with against which we could benchmark this aspect, these factors, these aggravating factors in a determinate sense. And again, I think there's a difference in terms of rigor that would be applied, and I think probably Professor Boxall in his presentation will sort of try to we'll point out that there can be sort of sloppy approaches to this, and then the more rigorous ones. And I think we want to encourage rigorous approaches, and I think certainly the defense bar will have an incentive to promote rigorous analytical approaches here. But at the same time, I think we have to understand that we're not doing this for economics, and we're not doing this for that purpose, but we're doing it for sentencing. And so I think judges should feel free, and I encourage judges, if there's any listening, to play with this stuff a little bit and see, how much do you want to rely on it, and maybe maybe if you feel that it's a little bit out there, then you take a very conservative approach to those numbers. But if those numbers are put in front of you, I would suggest that certainly Parliament has invited you then to use those numbers and play with them and see what you can come up with.
I just had a question. It occurred to me as you talked about Banff Park, and you talked about the value of tourism and so forth. But it occurs to me that that economic value, the use value in that case, is antithetical to the non-use value. So some people would say that that's actually to the detriment of the park, and as you know, there's a lot of controversy about how we use the parks. So it's an odd sort of addition if you take use and non-use value. If you're saying, well, the use value actually is detracting already from the non-use value. So I'm not too sure how you reconcile that in terms of valuation.
So I reconcile it, so I have thought about that issue before, and I think my answer would be, the legislature expresses sort of the bargain that is struck in these contexts between the use of environment and the protection of the environment, and that's in the setting of regulatory standards, that's in park management, and it's sort of like when you commit an offense, you step outside of that bargain, even if that bargain doesn't make sense from a holistic perspective, and you're looking at it from a sort of holistic perspective. The fact is that that's where the bargain was struck. We allow certain kind of development in parks, and it might well be that that development is more detrimental, for instance, than this one incidence of an individual or a group of individuals on their ATV trashing, a wetland. But the reality is that we've sanctioned the other behavior, and we haven't allowed this behavior. We prohibited this behavior. So when you do that, the ATVing and whatever, and it's contrary to the law, then we're going to punish you, and I think we can apply these principles in that context. But I agree with you. The same point was actually made in Carrier, where the hunters said, fine, we took a couple birds, but actually there's a hydro dam upriver that causes way more damage to migratory birds than we ever have. And the court says, I have some sympathy for that, but it doesn't detract from the fact that what you've done is illegal, and that's a separate issue. So anyway, so that's on the risk side. I think that because of the probabilistic nature of the exercise, we're not dealing with the sort of, it's not compensation. We don't have to get exactly right. And remember that the language here is that the court is to take into account the gravity of the aggravating factors. And so again, I think there's room for a court to say, even if the argument is made that this is, so I think in Canfor the court described this kind of stuff as airy-fairy, and I think when Peter's done with you, you'll know very clearly that this is not airy-fairy stuff. But even if you want to be a little bit skeptical about it, you can take whole fractions off, like whole powers of 10 off these numbers, and still come up with fairly significant numbers. The other difference, so as I mentioned earlier, there are two essential differences between tort liability context and the sentencing context. And so the big one here is that whereas in tort, the burden of proof is a balance of probabilities, right, 50% plus 1, here we need to prove our aggravating factors beyond a reasonable doubt. And I actually don't know that what I'm about to say is less about the difference between a balance of probabilities, and that should be an O there, I'm sorry. Yeah, I put BRD twice, great. The top is supposed to be balanced probability, BOP. Really my point here is just that Crown Counsel and their client departments that they're representing have to do the work. You're not going to get anything from the court on these fronts if you don't introduce the evidence. And I think that that's a constant sort of plea from the judges, starting with United Kino, right? In United Kino, Justice Stewart said, we generally need expert evidence to quantify environmental harm. We will need that expert evidence. And I think it has been a little bit like pulling teeth, and there are lots of good reasons for it, I'm sure, and I'd love to hear some of them. I think some of them are institutional. I don't know if we have the sort of incentive set up right to incentivize Crown Counsel and departments to go out and generate this kind of evidence, because as Peter will also explain, there are some cost issues here. But the point that I want to make clear here, and this Zelstoff-Selgar Limited case is a perfect example. I mean, this was a huge spill into the Columbia River, where we know we have endangered species, we know we have all kinds of fish, we have all kinds of other important environmental assets, and yet at the end of the day, the court said, I don't have any evidence upon which to sort of take into account these aggravating factors of harm and risk of harm. So really here, it's really just on the importance of showing up, as I sort of alluded to. So my final thoughts before handing this off ties into one of my comments in the context of the last presentation, which was on negotiated sentences. I've noticed, because I've been searching for case law, right, in this context. I constantly am updating, seeing whether or not there are new decisions coming out that in the environmental sentencing context. And it's not a rigorous science, it's not a random survey, so I maybe should do one. But anecdotally, I'm seeing a noticeable increase in the number of negotiated sentences where there is no sentencing decision. And just one such example, if you go to Environment Canada's, so this is the offense notification website that I discussed, I mentioned before, and I mean, I don't think for any one of these, actually, in 2013, there's a sentencing decision. And there's some big numbers here, some of them, $100,000, $350,000, $75,000. There are some big numbers here, not quite as big as Syncrude, but they're getting there. And so the question is, though, if all of this is done inside a black box, that is negotiated settlements, then I don't know that, well, we're certainly not going to see developments in this area and on this specific question of environmental valuation. And so on that point, I think I would borrow actually the dicta from a recent decision from the Supreme Court, and I think Sean alluded to this too, that this point has been made in the context of private arbitration and commercial law. You could substitute where you read here private arbitration, just read negotiated settlement, or negotiated sentence, I should say. Negotiated sentence is increasingly seen as an alternative to a slow judicial process, but negotiated sentencing is not the solution, since without an accessible public forum for the adjudication of disputes, the rule of law is threatened and the development of the common law is undermined. And I think that's certainly we aren't going to see any development on this front. And I should, and I don't have the case law up, but there's a lot of sentencing jurisprudence that talks about the educative effect of sentencing, and I think that's part of the ethos actually behind creative sentencing, is this idea that there should be an educational sort of component to this. I feel like that aspect, the development especially of the common law, is going to remain stunted if we don't force the courts at least to grapple with these issues more and more. I'll leave it at that. I'll invite my colleague Peter Boxall, and then we're going to take questions afterwards together. Or during, that's right.
All right, while my presentation's being loaded up, I think my friend here set up a bit of a straw man. Sounds like I've got to address a lot of different things in a short period of time. But let me tell you all that, I guess I'm the only non-legal person here, and I've actually learned a heck of a lot. So I've been in the back there taking notes, and I've adjusted my presentation about 5 times, and so we'll see what happens. Okay, so I'll just delve right into it. So this is one of the slides that I added after listening to yesterday. What needs quantifying is one of the questions that I'm asking myself here. And we've got these 3 different areas, I think, where you've got the punitive aspect, which is the fine, deterrence. An economist looks upon this as an expected penalty, right? So what does the violator look at? He looks at the size of the fine times the probability of being caught, and which is, I think, is really interesting. That's what you kind of talked about, Martin, with respect to the risk of damage or risk of loss. But the other thing that I find interesting here is that obviously the Syncrude case, I thought Sean was kind of conflicted in what he was talking about, corporate responsibility, and yet at the end of the day there was the credible threat of the 1,500 ducks times the individual charge in each case. They're obviously looking at some calculation like this and making an assessment as how they want to make the case go away. So I think there's something there. And then, of course, the other interesting part of this is what's the marginal expected penalty? What policy or enforcement action do we start to think about as an enforcement strategy that might modify that expected penalty? And you can work on both sides of the equation. You can increase the fines, as we see in the Act. You can also hire more inspectors to catch, to increase that the chances of being caught. And then the one I'm really struggling with is this risk of loss, the environmental protection, the potential for harm, the risk of damage. I think Martin's nailed it on the head, is that I think we need to provide some range of values that make sense. That's the only thing I can think of there. And then, of course, this is the one I can speak to the most, and this is the damage remediation compensation part, where, using Rebecca's words, you pay the Crown for the purposes of promoting conservation and protection of the environment. So there we're generating a public benefit or a value that could be used for restitution or whatever. And then in this whole thing, I think we've got to realize what the role of the government or the Crown is in this, and it's just to protect and provide public goods. You know, coming from Alberta, sometimes I think this tends to get ignored. Well, let me start this off, and you know, this is going to be at 50,000 feet. Okay, what is an economic value? Well, it's a utilitarian anthropocentric concept where we think, as economists, we can identify some mathematical function that measures your happiness. Okay, so we have a utility function, which is a function of a bunch of arguments. One of them could be income. Okay, so how do people trade off these services? You know, assuming that happiness is the goal. We're interested in understanding how their behavior may change as the environmental conditions change. And what we attempt to do, just as a convenience, is to convert this utility into money. And this is where we come into the aspects of the damage assessment and the compensation. Now, the leap of faith, I think, that Owen talks about, where this was a really slow idea to develop, was the fact that it's pretty easy to recognize now that some of these arguments in a happiness function can be environmental attributes. And I think that's what's now led this revolution you may think of in economics. So here's when I teach students this, foresters, for example, that don't know anything about economics, I call these happiness maps, and you can imagine as your income goes up, your happiness goes up, and as the environmental quality, if you're a hunter, if the number of moose go up, well, you're happier. But of course, you don't want to see anyone out there on the landscape hunting with you, so you can imagine some of these might go down. Okay? So you can imagine in that happiness mathematical function, this would have a negative coefficient, and these other ones would be positive. So you always want to see a positive marginal utility of income. Now, it might taper off, but nevertheless, the more money you have, the more happier you are likely to be. What's key in this, though, is if you have to understand what the current condition is. And here is a map of environmental quality. We know that we're currently at 6 units of environmental quality. We have an incident or some harm that decreases that down to 4. So now we've lost 2 units of happiness, 2 units of utility. And the question is, how do you compensate for that? Okay? Well, we think it's pretty easy because you just provide enough income to bring them back up to where they were. And essentially that's, you know, a back of the envelope, probably 50,000 feet idea that works in this philosophy. Okay? So we want to provide enough income to provide 2 units of happiness. But in practice, the losses are valued higher than gains. So here's an outcome, and it's the same distance. There's a gain and there's a loss, and we usually find in empirical practice that measuring a loss is a lot bigger than measuring a gain. And so this is called a willingness to pay, and this is called a willingness to accept compensation. And when you actually measure these things, you get this difference. And of course, in some cases that can be contrary to economic theory, although it's been shown that it can actually happen due to various characteristics of the situation and the goods involved. But nevertheless, when you're thinking about compensation, it's usually going to be a big number, whereas most of the information that is available is in willingness to pay. Okay? So these are going to be a conservative estimate. All right. So I've talked about this. Loss can be measured as values of benefits foregone as a result of harm. That's an important concept to keep in mind. The costs of reversing the harm are probably different, but nevertheless, it's a reasonable approximation. That's an important point to keep in mind. The loss could be expressed in other metrics. This is exciting to me. Forget income. Why don't we compensate for a loss in some other way, using one of the other arguments of the utility function? This is what you start to see now in U.S. damage assessment, where if you're going to have an oil spill and you kill a bunch of birds, one of the measures of compensation may not necessarily be a monetary compensation measure to make up for the loss in viewing the birds, maybe you can get the company to build a interpretive museum or a wildlife viewing infrastructure that would generate positive benefits as the resource recovers. And in theory, that construction of the infrastructure could compensate for what you might have lost in terms of the income that you'd actually generate, the money. What makes that interesting is that now the firm can actually construct that infrastructure at least cost. They have some control in how that thing might actually come about. So me sitting in the back listening to the creative sentencing, I think this is a really interesting economic intuition that could enter the discussion. So it might be useful in a creative sentencing context. This is the big action. This is time. There's the resource value, and it's the top line. You're bopping along. However, at time equals 0, you have an incident, and the value drops. Okay? And if you leave it to come back in a natural recovery process, you're going to get it over here. Whereas if you force the firm to intervene and start working on making a faster recovery process, you're going to be back to the value here. Well, what's the value of the damages? Well, it's essentially under the natural state, it's A plus B, the area there. Under the new one, where the firm actually starts its own active restoration plan, you're only going to be looking at area A. Okay? So there's an incentive then under this particular type of policy for the firm to clean up the mess as fast as possible. Now, we have a lot to say as economists in terms of measuring A and B. So we're back in that third one that I talked about in the first or the second slide, measuring compensation for damages. So this is called the interim lost value. Okay? And that's something I don't think we see a lot in the Canadian context, but this is what our literature is spending a lot of time thinking about. Critical issues though here, what's the base case? What's the pre-damage condition or reference point? It's really abysmal in the Canadian context, not only in science, but social science, understanding what that base case is. For in the Syncrude case, how many birds visit those tailing ponds? You know, what does the 1,500 birds mean in terms of a marginal change in the population that visits them? Is there any data on that? I doubt it. And we haven't even entered any economic situation or context yet. So it's really important to understand what we call the base case or the reference point, the pre-damage state of whatever the resources that you're talking about. The science comes in forecasting or knowing what will change in the new state. What's the post-damage state? Okay? This requires, of course, the biophysical knowledge as well as social and economic information. Okay? And, you know, if we can't understand the base case in most cases, we're certainly going to struggle with this. This includes on-site effects, off-site effects, use values, and non-use or passive use values. Okay? So it's a big job to do this, quote, properly. So how do you value the harm? The cost of the cleanup or the restoration, one would assume, might be relatively straightforward. I've got question marks there because I can see where it may not necessarily be. But the interim loss of benefits until the harm ends might be also straightforward for those goods and services that are traded in a market. You know, visitor days, minerals, prices and quantities exist. Probably, maybe in some cases, even in the base case. This is really a challenge, and this is what we're really talking about here, I think, is the concept of a non-market value. The things that are not traded in markets where we don't have well-defined prices, but we might have some quantities, okay? So this is the challenge, the big challenge, as I see it in this area, and I'm sure Martin would agree. So I'm going to go through very, very briefly, and tell me to stop when I'm out of control, okay? I'm going too long. I'm going to start with some use value contexts. So this is a very strong way in our literature of estimating these values, because what we can do here is we can identify linkages between a market good and an environmental good and use these links to assess the values that you might see that might change with some change in the environmental state. We call these revealed preferences, okay? They can only be used for use values, because I can see Jim using a park. I can see Sharon buying a canola oil with a fair trade label on it or something like that. I can see this. You guys have made active choices about doing things in a more or less quasi-market state. So this works for use values. Some really good examples for recreation. The kinds of things you see here are travel cost models. There's a new one called a random utility choice model. Other examples are things like hedonic pricing, which is another very powerful technique. And here's an example of something I've done where I've looked at the impact of sour gas wells on property values. You can observe property transactions. Those property transactions have the characteristics of the properties in them. Some of those characteristics can be environmental conditions like proximity to a wetland, proximity to a sour gas well, right? Being close to an amenity like an open space area or a park. And you can see here that as the number of sour gas wells, so if you're here at a house, this is the base price that you pay. Being subjected to a sour gas well, the first one is worth about $6,000 in the average property around acreages in Calgary. The next one adds not this much, but less. So you've got a diminishing marginal effect of each additional well being added. You know, as you're living in your home, as more and more get added, the effect gets less and less, but you're still going to add all these numbers up. Okay, and that's the top graph. So, you know, of course, the oil industry doesn't like to hear this, and they claim this study doesn't exist, but it does, and it's published in the literature, and all that kind of stuff. This is an example of hedonic property valuation. These have been done for wetlands, they've been done for sour gas wells, open space. There's a massive literature in this area. A recreation case here, I'm going to walk you through a very simple travel cost model. Imagine a recreational fishery is damaged by a pollution event. There are resident and non-resident anglers that fish there. The non-resident anglers are valuable because they bring new money into the region, so their expenditures really make a difference. A resident expenditure does not make a difference because if the fishery closed, instead of spending money going fishing, I'd go bowling. So the money still stays in the region. So expenditures are not values in most cases. Where they do matter is if it's new money coming into a region. And the best place you see this in the fish and wildlife area is with non-resident anglers and hunters. The extent of the damage to the fish population is determined by biologists. Let's assume that data exists on the number of visits to the river by anglers and that this information includes angler characteristics. Typically, we have no idea. Biologists know more about the fish than we do about the anglers because they do creel surveys. I'm going to come back to this because I think we need to fix this kind of information to be able to get the kind of data that I think we need. So the costs to enter the fishery on a trip are essentially zero, but anglers pay travel costs to get there. In other words, their income drops as a result of visiting a particular river. So we need to know where they come from. So one of the first things that we should be asking people who visit a fishery is, you know, what's your postal code or where do you live? Very simple piece of information. I'm going to show you an example at the end of the talk. License fees don't matter in this area because they're not specifically tied to the site and they're not determined in a market. I worked for the Alberta Fish and Wildlife Division for 10 years, and I can tell you that's exactly what happens. A number is pulled out of the air. Okay, so $15 a year to buy a fishing license, and you can fish anywhere you want. It's not the cost of a trip to that particular fishery. What do we need to know? We need to know what behavioral changes might we observe by the folks that use the river. They might take fewer trips. They might switch their trips to some other river. They might pay additional travel costs to visit some other place. There certainly might be fewer trips by non-resident anglers and thus lower levels of expenditures and tourism revenue that comes into the community. If we knew where the anglers came from, though, the resident ones, we can estimate the cost of access by building a travel cost model. So what is this? This is a simple regression model where the number of trips per year is the left-hand side variable, right? Down here. And the price is the travel cost, and you would expect downward sloping demand. And I've done, 50 of these, and you always find this kind of demand system here, decreasing cost. So the more trips you take, for example, if it's really cheap to go, you'll take lots of trips. If you live in, say the river's near Halifax and you live in Fredericton, well, you might only take one. Okay, so that all kinds of this is the underpinning philosophy of this. If this is the average travel cost per angler, There's the average number of trips per year. This area of the triangle above this dashed line, right, is essentially the estimate of the value of that fishery. Okay? In other words, you could, as you take more and more trips, you're willing to pay less and less and less, but your first one you were willing to pay a lot more. So this area is called the consumer surplus. It's an estimate of the willingness to pay in the aggregate of all the anglers who utilize that fishery. Okay? So if the harm reduces of the site to 0 trips, then for the average angler, the loss is the area of the triangle above. Okay? If it reduced it to here, then you got a second triangle and you compare the 2 areas. Very simple to do mathematically. Okay? So this is the philosophy of a very simple travel cost model, and this was Jack Knetch is the first guy to work on this. Okay? This is this isn't Cadillac economic science, but we could do this if we had the right data. And in most cases, we don't. So this is an estimate of the value of the recreational use of the fishery. Note in my case there, I assumed a complete loss of the fishery. But the dollar per trip can be used to assess trip decreases. This ignores possible use of substitute sites. So if you had really good data, you could make this model much more accurate by including other places they may go to fish where the quality doesn't change. The other thing is, the pollution event, or whatever it is we're looking at, might actually affect the quality of the fishery. The fish could become smaller, the population decreases, therefore it's harder to catch one. Okay? And these might all be things that would feed back on how many trips you take to that fishery. So at least it's a start. And if we're in the world of ballpark estimates, then this is a reasonable thing to think about. So I've talked about revealed preference methods, good for use values, well respected in the economics literature because they use observed human behavior and observed folks making choices of things. Therefore, there's not a lot of argument about those particular methods. The second area is the non-use area, and this is where you're going to develop or you're going to create some kind of a hypothetical market to incorporate environmental changes. And you're going to estimate the welfare impacts using these hypothetical markets. This is called stated preferences. That's a term Martin used. This requires surveys, conversations that elicit choices from people, okay? Using hypothetical referendums in most cases. I'm going to show you some of these. It's the only method we have for estimating passive use or non-use values. Contingent valuation is one of them, and there's been a lot of work done on that method, as Martin alluded to. The other one that we use now is called stated choice or choice experiments, and I've got some examples of questionnaires that I can show you. So I'm going to walk you through an actual valuation example that Martin brought up, and this is this threatened and endangered marine mammals in the Gulf of St. Lawrence. Most of the cases of non-use value that I've worked on arise from a result of species at risk issues, largely a result of regulatory impact assessment, where Environment Canada has to do a benefit cost analysis for the species listing. Listing a species endangered is construed as a regulatory change, and therefore it triggers a benefit cost analysis. Where do they go? They come to me and they say, we need to do this. And I say, yeah, in order to do this, you need a recovery plan, because that's the management action that you're going to take. So now you're forcing biologists to come up with a recovery plan before they have to, right? So it's kind of a back of the envelope thing. So what I'm going to show you, and a lot of the numbers that I have relate to recovery plan actions of endangered species, okay? So the rationale here, there are several marine mammal species at risk in the St. Lawrence estuary. Living in Western Canada, I had no idea that this was a biodiverse area in terms of marine mammals. It must be incredible to be there when these things migrate. And here it is right there. There's the St. Lawrence estuary. It's close to the Gulf of St. Lawrence. And these are the species that are there. What triggered this was the beluga whale, which is a threatened remnant population. I had no idea that existed there. I thought they were in the Arctic. There's a harbor seal in there that's also threatened. These are all the seasonal visitors. Anything in red is endangered, so blue whales and right whales appear in there. So you can imagine this is a dream for marine mammal biologists to study there, and a constellation of species at risk issues. And they're all charismatic megafauna. All right? Everybody likes to see whales. And I don't know about seals. I guess the fishermen don't like them. So one of the things they wanted to do is they wanted to create a marine protected area as an action plan for the recovery of, in particular, the beluga whale. And, you know, they were talking about a small protected area, or they could do a large one, which included the small one. Okay, imagine making the whole estuary a marine protected area. So this requires the socioeconomic analysis, as I talked about. There was already a recovery plan for belugas in place. What are the economic benefits of recovery programs for all the marine mammals at risk in that estuary? What are the benefits of increased populations of whales and seals? It's not a damage case, so it's not a decreased population. We're looking at an increase. Okay? So it's important to know. This involves lots of commercial enterprises. Hence, some well-defined prices exist. There's a whale watching industry there, for example. There's also the transport of goods and services up and down the river. So there are non-use values. We call them passive use values. There are no behavioral trails to examine, no prices. Hence, we must use stated preference methods, which we're going to involve some simulated markets. Lots of, I'm going to walk you through this. This took a year to do, so lots of work. You had to convince the biologists to give us, species population trajectories. We had to look at all the different types of threats. And we ended up using a little instrument like this. This would be a contingent valuation exercise if this was the only thing you saw, okay? So right on this side are what we might call attributes. So we've got three different species. We've got the size of the marine protected area. We've got the possible imposition of regulations on shipping and the whale watching industry. This is the current situation. So we've defined a base case. And the base case is, the best that we can tell, is the real thing that is actually happening at the time we did the study. Right? Your taxes stay constant. Here's a management change. We're going to increase, for example, the species status of harbor seals while holding everything else constant, except we're going to add a small marine protected area, and we're going to impose some regulation changes on the shipping industry and the whale watching industry. Okay? And we're going to give you a randomly drawn number that your taxes are going to go up by this. Okay? Now, that would be a contingent valuation exercise. That would be the end of it. What we do is we do a whole series of these with each person. So this now becomes kind of a stated choice analysis. So that's really one of the ways that you distinguish a contingent valuation exercise from a stated choice one, is the number of valuation scenarios and tax levels that you provide an individual respondent. Okay? So these guys are asked to look at these things. If you had to vote on these two options, and we have a lot of text above about a national or a provincial referendum, what would you pick? The current situation or the proposed program, right? And respondents answered multiple scenarios in which taxes, restrictions, and levels of the species recovery improvement varied, okay? So you put this together with a sample which was representative nationally as well as regionally, because we wanted to know how the local folks around the estuary would respond to these programs. And the results are about anywhere, depending on the size of the program, $77 to 229 Canadian per household per year, okay? So those for 30 years. So we said this would take 30 years for this program to actually work. Okay, so aggregated nationally, this is the number that I think Martin showed you, the lower bound one. If you aggregate those numbers over 12 million households nationally, you come up with some pretty big numbers. So they ranged here from about almost $1 billion to almost $3 billion a year for 30 years. Okay, so not insignificant numbers. Our challenge is we do everything we can in these scenarios to make these numbers conservative. And this is willingness to pay. It's not willingness to accept compensation. Okay? We look at all sorts of ways of adjusting. Folks who say, yes, I'm going to vote this, we go back, are you really sure? And if they say, well, I'm not completely sure, well, then we assume you say no. So we do all kinds of things possible to come up with conservative estimates of these values, because these numbers can be massive. That polar bear one, I just don't believe that. $6 billion a year. What makes this interesting, though, and you always look at the results of these. If you just looked at the harbor seal and you were going to move it from threat to special concern, that's the number. It's $77, okay? If you were to add to that though, or sorry, if you were to now look at the beluga whale, which I think is a more charismatic megafauna than a harbor seal, they're willing to pay $34 a year more. That kind of makes sense to me. If you were to look at both of them together, right, now you're up to $72. So there's a difference between this and that, but it doesn't differ by much. 72 versus 77. Okay? If you were to add an extra layer, an extra recovery plan, in other words, make them even better off, they're only willing to pay an additional $23 above this. So we're getting this diminishing willingness to pay as you add more and more environmental improvements, which is exactly what you see in markets with products, right? And here's the Cadillac one. If we were to add the blue whales and move it from endangered to threatened, they're only willing to pay 21 bucks more. Okay? So when you go back and look at this data and you see this kind of stuff, this is what keeps us awake at night. Do these numbers make sense? And they kind of do, right? So these are all the things that we do to examine these numbers to make sure they're, quote, credible. So,
Can I ask just a practical question, Peter? As you point out, that works for environmental improvements. You'd ask a different question if you're now talking about compensation. You'd ask, what are you willing to accept? And that figure could be 2 to 5 times different, you know, for things like wetlands and stuff. They've shown that. And the question is it just as easy to do this type of survey after there's been damage, when people are affected by it? And so
that's
as a practical matter, how do you get at willingness to accept?
That's why I think you've got to use this kind of data, because A, it's a conservative, right?
But you know it's wrong.
But you know it's wrong, but it's in the
and
right
sometimes
direction.
by a factor of 2 to 5.
Well, sometimes. But if you were to do a survey when something has already been lost, you can imagine that the public reaction would be even that much more worse.
Mm-hmm.
It would be much more interesting to do this kind of work if you were to think there would be a future loss.
Yeah.
Sorry, am I not on the mic? Sorry, I thought my voice would be loud enough. But I mean, that's a really good question. Okay, what does this mean? How to use the information? It's apparent that values for species existence are large. These values, exactly as Owen said, are for improvements. Degradation would at least be the inverse, but likely larger. Losses are valued higher than gains. The base case is already threatened in this case. If you made them extinct or extirpated, I think you'd be looking at some significant numbers, okay? So this would be a case, I think, where you're looking at this risk of harm. I think this information, not only if there is an actual case, but this would be very interesting to think about in a risk of harm scenario. So what do you do in cases of harm? In most cases of harm, this kind of data doesn't exist. Can you transfer benefits from one study to another? This is where everyone's going with this. And Environment Canada, to be honest with you, is a leader in this area. It's actually created something called the Environmental Valuation Resource Inventory, which is probably the biggest inventory evaluation studies on Earth. My question is, do we have enough Canadian studies to transfer values? You'd be pretty hard-pressed to convince me that we could take a number associated with wetland conservation from 1975 in Colorado and claim it has some relevance here in Nova Scotia. Okay? So I think I mentioned this to my Environment Canada friends here. Instead of hiring consultants to gather data, why don't we do some studies that we can populate the resource inventory with, that we can then start thinking about doing serious benefit transfer. One of the reasons that polar bear number is 6 billion is that they used this database, okay? And I think it was was it the value to Canadians or was it the world? I have no idea, but you mean polar bears exist in other parts of the world too, right? So even if you made them extinct in Canada, they may not be extinct globally. You know, I'm playing the devil's advocate here, but so these are some of the problems that we face. So I think benefits transfer is a really interesting idea, but we need to add more Canadian studies to the database. And there's only nearly 2 or 3 of us in Canada that are ever doing these studies, and we only get funded to do them largely now in a species at risk case. DFO is the one department that pays them, that is the one agency that's actually funding a lot of this work. They funded that marine mammal study, for example. So why don't we have Canadian studies? There's a lack of investment in research, in particular data collection and inventories of resource use. We know more about woodland caribou than we do about what they're worth or how they're used, okay? There's a lack of human capital in this area. There's my colleague Vic Adamovich and I are probably the two folks who work the most in this area. There are others around that are trying to do this area, but there's just no funding in this area. There's not a viable consulting sector because up until recently there's been no demand for this kind of data. And the environmental issues are the purview of biophysical scientists, and they're the folks that populate provincial and federal government agencies. They don't think this stuff is that important. So to me, sitting in this meeting, I think the legal system has the ability to influence how much work we do in this area. And I think it's really important that, I mean, it sounds rationally self-interested, but I mean, I think we need to do more. Back of the envelope estimates are good enough for the biophysical scientists, but when it comes to court, it should not be good. We need to do a better job. Okay? So yeah, I'm on a soapbox here. Why is this? There's an unlimited resource base. There's not really any need, was the philosophy back in the day. There's no legal requirement. Species at risk is the first entry point. Maybe you guys can create some more. The freedom of information requirements makes research, or at least gives a perception that making research would be very difficult. Let me give an example. I wanted to get my hands on the EcoGIF database, which is where citizens can donate land for conservation purposes under an easement to a land trust. So I go to Environment Canada and I say, I'd love to get this data. I want to do some research on it. Well, we can tell you how many acres were. We can't tell you where they were, and we can't give you the value of the gift because that's under the Income Tax Act. So, I mean, we can't even study some of the fundamental policy mechanisms that we have in this nation because of the freedom of information. It just makes it too hard to do. And then there's a lack of a political willing. In the Alberta context, they don't want to know what the numbers are, right? Because then it's going to show up in court and it's going to reduce the footprint of the industry and that sort of thing. So I go, one of my questions is, will this emphasis on sentencing increase the focus on valuation? I think it has to. The information is also useful beyond damage assessment, regulatory impact assessment, for example. Health Canada funds all kinds of valuation studies on human health impacts of the Chemical Management Act and other things. Why can't Environment Canada do this kind of work? This type of work will be more successful for use values because it's cheaper and easier to collect the data. There are lots of existing procedures that can be modified to collect necessary information. At dinner last night, we were talking about national parks. National parks collect permits for visits in backcountry areas. It'd be pretty easy to estimate a backcountry valuation model if you could get your hands on the data and if they ask the people where they came from, right? So there are all kinds of sources of information like that lying around that by adding a couple more questions or collecting the information in a different way that wouldn't probably impose any costs, we could start being able to do this kind of data. So there's accounting processes for user fees for park visits, there's creel surveys, there's hunter-harvest surveys, all kinds of things like this I think are opportunities for us to be able to collect the data. Here's an example of one we did in Alberta. So the top one is a little card you fill out when you visit a campsite, right? This thing was designed for nothing more than the accounting purposes of collecting the money. So the number of camping nights times the fee, the amount you put in the envelope, it asked for your surname and your license number, and then there was the dates and the campsite you were staying at. So we went to them and said, if you add this little sticker to each card, which asked for their postal code and something about how many times they'd been there in the past, we estimated a really interesting travel cost model for the central part of the Rocky Mountains, and we could value a camping trip at $58. Notice the fee to go there is $9. Okay? So we had a non-market value associated with a recreational use value by just changing that form from the top one to the bottom one. That's how simple it is. Will the emphasis on sentencing increase the focus on valuation studies? I think so. For non-use values, increasing the number of studies will allow us to do more more accurate and viable benefit transfer exercises in Canadian context. I think that's exactly what we have to do. And I think that's my last slide.
Martin, perhaps you'd like
Got
to
lots of examples of stated preference servers if you want to look at it.
We'll open the floor for questions now. I should warn you, if you don't ask quickly, I'm going to hog it. So, got lots of questions. It seems to me that one of the things that one can take from this that has very practical value, and this distinction between how we value gains and how we value losses. And I think that's intuitive to most people. If you ask somebody, how much would you pay for this ring, you might say, well, that's worth $100. And if I ask you, how much will you accept for me to take your wedding ring, they might say it's a lot more. Well, in some cases, they might say a lot less, I suppose. But assuming it's a happy marriage, they would value the loss greater than the gain. It seems to me that in terms of how we structure some of these settlements, these creative sentences, that has real insights in terms of whether or not you structure it as a gain. For example, a lot of references to bursaries being given out, right? Those would be, I think, assumed to be gains, as opposed to structuring it as a remediation of a loss. So you could spend a lot less to say, well, we're doing something to remediate the loss, and get the same happiness out of it if you spent a lot more with these sort of tangential benefits that are perceived as gains.
I would certainly agree with that. I think that's a brilliant insight. Why don't you use creative sentencing to create an endowed chair at the U of A in valuation? I'm too old for it. I'm too old. Okay. So you get a young Turk in there who would start to think and work on these things. I think that would be a really. I mean, that's obviously going to be a beneficial thing.
It's something that corporations would love, because they can get the same happiness, presumably, by spending less, as long as it's structured appropriately.
Right.
And it really does go, though, to how you use the funds from a creative sentence. So,
I agree.
Yeah. Question, Martin, you mentioned that there weren't any cases dealing with this yet. And perhaps you know too, Peter, have there been any case, but there'd be lots of cases, but I don't know if they've adopted some of the approaches you talked about. There is an area where you have lots of compensation, and that's in expropriation law. I mean, there are all sorts of tribunal decisions in terms of expropriating individual properties and so forth. And the same question comes up there, of course, only you'd probably think of it as called an endowment effect or something. That is, how much do you pay this person to take away the 100-year-old family homestead? Do you pay them market value of a house next door? Or do you take into account the fact that there are existence effects, that is, the family home? And I don't know if you know whether or not there's been any developments in compensation law.
So I would qualify. I'll qualify the first comment to say, it's never been successfully done, but actually there are two cases in Canada that we can say that this question of economic valuation has come up, and so one of them I cited in my PowerPoint, R versus Carrier, and in that case, this involved the migratory birds, and the court essentially pleaded with the Crown to introduce evidence about the value of migratory birds. It's a pretty exceptional decision from 2005, where the court, I think, seemed to, the judge there just had this prescience. He's like, already at that point, the Migratory Birds Convention Act told him that in assessing some of these Keno Hill factors were already codified in the MBCA at the time, and he said, the Act tells me to consider the value of migratory birds, and he's like, well, so what is the value? And he was saying to the Crown, give me some evidence. What is the value of migratory birds to the hunting industry? And then he went on to say, some of these other values, and he cited the Migratory Birds Convention, actually, which talks about their aesthetic value and the forage, the pest control, all these kinds of values which are expressed in these instruments. And he said, maybe some of them are impossible to quantify, like the aesthetic value. And so on that one point, maybe he was wrong, but I think I forgive him entirely, because the general discussion of that decision is essentially, the tenor of that decision is, let's do this. The judge was totally willing to accept this kind of evidence. The other case that we discuss in our paper, and we do a sort of a thought experiment with, is, I'm going to forget the name, it's a PEI case.
It's a
fisheries case. It was a Fisheries Act violation. In that case, actually, Environment Canada, it's an earlier one. It's 2004, I think, or 5 too. And there was actually an effort by Environment Canada to sort of quantify the economic damage here. The problem is that they did it sort of entirely in the abstract. And in our paper, we sort of, and Peter especially does a fairly good job of pointing out, well, what did we need here? We needed some empirical data that was grounded in the place, because Environment Canada introduced evidence which essentially was very hypothetical. It was just like, well, we might have less fishermen, and they might not stay, and they might not fish there, and then they don't travel, and like all this kind of stuff. And it was the right sort of thinking, but there was none of the empirical data.
And the judge threw it out.
And so the judge threw it out on that basis. He's like, I can't buy into this. So we have these two cases, and I think it's also fair to say in that case the judge was kind of skeptical. He talked about, values that economists believe, I think is a word he used. And I don't think it's a matter of belief in this case, and I think that Peter hopefully convinced everyone of that too. So, so we do have these precedents, and I think they are important precedents. I think in a case, if you were going to be serious about this, you would want to cite those cases as a sort of creating your parameters, and then jump into it and do it, the way that we were talking about here, and give it some rigor.
If I can just offer an observation there, both lawyers and economists at one time tended to assume the existence values away. That is, non-pecuniary values were difficult to measure, but they had a charming phrase for it. They called it mere delights sometimes. These were sort of trifles, things like a nice landscape and so forth. And I think one of the values of economics over the last 2 decades, 3 decades, is that they show that there's actual real value. They're not mere delights. Peter, just finally, for me, and please, I said I was going to hog this. The surveys you talked about look like they're really expensive. And so I wonder how limited the use of contingent valuation is. Are there ways of reducing the costs of those so that they can be used in a broader range of cases?
That's how benefit transfer came about, because the cost of the surveys. In fact, I think in the paper now I have a footnote, I think, where I give you the number that we would want to have a graduate student work on. These are all graduate projects, right? And it's something like $120,000 to $150,000 a survey. So I think what you need to do, if you were to take a strategic planning view, you would want to start to think about a couple of surveys you might do nationally on seminal environmental issues that could be used in a benefit transfer context. I think that would be a really interesting thing to think about, so that you'd have a modicum of investment in there, and you would actually be able to generate some values. And it may even be interesting to have the legal professions be involved in these kinds of things, in the choice and the design. But I mean, those numbers are nothing compared to some of the biophysical surveys and money that scientists spend surveying birds and so on. So I don't necessarily believe that that's a problem. But I can see if you had to do a survey or a study on every single thing that you needed to value, then it would be a huge issue. Absolutely.
I was just wondering, this is from a lawyer who ran like hell for math and after high school, so I may just not be understanding some of the concepts. But in terms of how do you deal with instances, or is there a way to value in relation to things that perhaps do not have a market value or a market equivalent? And I'm thinking of things like traditional Aboriginal use, where if you've got, the thought popped in my head tied in with the oil sands, but certainly in the north as well, in terms of where you've got something occurring out of an offense, and so there's a loss of traditional Aboriginal use, and so because there's perhaps not necessarily a market for that, or something that you can equate a market to put a value on, how you come at that. And similarly, would you if it were something, say, in the north, would things like, say, where it's affecting, say, a traditional food source, do you factor in things like studies that show health impacts on Aboriginal populations?
Yeah, absolutely. So let me give you an example. In the paper, there's a study in the state of Maine. There was a river that went through a reserve that was a seminal part of their traditional use. And the river had been polluted. And John Duffield out of Montana with Industrial Economics, which is one of the big consulting firms that does this work in the States, did a contingent valuation exercise using the same methods that I'm talking about, a referendum, because Aboriginal people do lots of referendums, probably even more than the rest of us. And what they did is they asked for a willingness to pay to look at these two different places here of recovering the river. And they could come up not only with estimates of the value, but they could come up with an estimate of their time preferences and having this work done sooner rather than later. And that's the only study that I know in this area that really deals specifically with a traditional use case that I think was pretty successful. I'd love to go back and find out more about, you know, what the community thought about this. I know they did a lot of work because there were a lot of people living off the reserve. They surveyed them too, and they had no differences in the values, which I think is a really interesting way to benchmark the case. I'm involved with 2 Métis settlement cases right now where a consultant thinks they can do this using really bizarre methods. And it's for loss of cultural heritage and use. So it's starting to happen. Okay, but you're absolutely right, it's a challenging case. Human health is a really interesting one. The numbers there are massive. And of course, you know, there's lots of work being done by the insurance industry in this, so the numbers kind of exist. But yeah, it's hard to do. And that might be a case where the creative sentencing part, when you start looking at, someone here had a case where the oil industry actually got involved with the Native community to plant and culture plants of cultural heritage. And
yeah, it's in Alberta Environment's creative sentencing.
See, that would be, I think, a really interesting way to deal with that. Not necessarily monetary compensation at all.
There's one other aspect, I don't know how much this would fit in, or whether defendants in particular have pursued it. You raise the issue of comparison to tort in particular. One of the areas that both tort and contract law have had difficulty with is whether to award cost of restoration as opposed to loss of value. And the two can be quite different. It's come up in contexts as simple as I asked you to build a house where this part of it was going to be so many inches tall and you were 2 inches off. It doesn't affect the usefulness, but I want the cost of restoration, which will be to tear it down and build it up again. And one of the biggest cases ever in that was actually in the environmental context, was the Bannerman Islanders in the Pacific, who had their island completely denuded for phosphate mining after the war, when the British refused to let them return to the island after they'd been excluded by the Japanese, and they destroyed the island essentially. And it was the longest civil trial in England up until that time, McGarry, that they tried to sort out, well, if we pay you the cost of restoring the island to what it was, we get into orders of magnitude different from what we might pay for compensation. In the sentencing context, you have it slightly easier because you're ordering the remediation. And one of the main reasons for not awarding cost of restoration in some of the cases, I think, is the suspicion that if we pay you to restore your property, you're going to take the money and buy a condo in Palm Springs. You're not actually going to use it for that. At least in remediation, you can order it. But have the arguments on valuation been used from a defense perspective to say there comes a point at which the cost of remediation is simply and utterly unreasonable in terms of the economic or other benefits, however we value them, that might be obtained by that remediation, and some other type of order ought to be utilized?
Right, so I know that there's a decision in the United States that talks about reasonable cost of restoration. So And that's the civil liability context again. It's I can't remember, it's got like a name like a Princess Cordelia or something like that, maybe the Cordozo, SSS Cordozo or something like that. Case like that, which involved damage to one of the islands there. And yes, the court says something like, at some point it has to be the reasonable cost of restoration. If they dwarf sort of the value, the sort of economic use values, then there'll be some kind of limit there. Of course, in Canada, we've never, this is all right now still academic, even in the tort context, right? Can 4 open the door, but we haven't, no one's ever walked through it, so to speak, and tried to and establish the quantum damages that needs to be compensated. One case which I think will be relevant to watch for actually is the Lac Mégantic disaster. I think in this context right now, we know that there is, in addition to the massive loss of human life, which is obviously going to be a huge figure, there will be, I expect there will be a suing for environmental damages. The lake there was damaged, and it is a sort of municipal government that will be. We'll see whether it's a class action, but yeah. So that's a case that might finally be one where this work is being done. In the sensing context, sometimes it goes the other way. Restoration is relatively cheap. And the issue is this sort of, and the big question is defining, well, what is restoration? So in the case that I was talking about, this one, Casely, I think it's R versus Casely and Sons, is the one we discussed in the paper where there was an attempt to do this. Part of what the court did award was cost of restocking and monitoring. And in that case, it was a fish kill. It was an absolute fish kill. The river was closed for 2 years. And so those costs were like $12,000. So that's really not I don't think, in my view anyways, especially if you consider all the different sort of environmental, you talk about ecosystem services and all that kind of stuff, all those different environmental values, that $12,000 isn't getting there. Sometimes I know we also talk about if you do go the restoration route, then looking back here, it's like Peter described, interim loss. So for instance, you might order restoration, but then until your ecosystem asset has achieved that, return to that baseline condition, you might try to quantify the loss of use and non-use values in the interim.
That's what I was going to say, would have been both, not one
Yeah,
or the other.
yeah.
But, so I'm not aware of any case. That sounds like a fascinating one. To me, I would have thought the BP Horizon spill would have killed that company. But it hasn't. The stock dropped and now it's back doing as well as it ever did. Exxon Valdez, the settlement had, I think it was quite a bit less than the actual restoration costs. So those are the two big events that I know about in North America, and they were blips on the radar screen. So, yeah.
Yeah, we don't have the price tag yet on BP. The full
No, it hasn't.
Damages hasn't been done yet,
But now I think the last I heard is that the projections were less than what I thought it was.
By a long shot.
Yeah.
Any questions? Yes?
Yes, I have a couple questions. The first is really a procedural fairness question for prospective offenders. And my question is about the process of conducting research to quantify loss, the cost of harm, either before the fact or after the fact. Given these costs, the fact that it could take the government a whole year to quantify what the costs are, how are prospective offenders to engage with those numbers, with that process, with the gathering of data, so that if, say, for example, during the court process, they're hit with a figure of, say, 530 million or anything like that, to question whether that number is reasonable. And I'm thinking of maybe mid-sized businesses that might not have the budgets to send teams of scientists out to gather their own data. So that's a long question, but basically a procedural fairness question. The second question I have is whether there have been attempts to evaluate ecosystems or portions of ecosystem services as opposed to a focus on population, species, or organism evaluations, which it seemed to me was more in line with the marine mammal studies or numbers of migratory birds affected. So those are my two questions.
So on the first point, I guess I'll make a couple points. One is that it's sort of, and this is not, it's sort of a reality that the state, when it wants to, can usually outman and outdone pretty much every accused, right? I mean, it's one of the reasons why you're shaking your head, but I mean, but that's at least that's the conventional theory, and is that you have these resources behind the state has all these resources and they can do all this work, and it's one of the reasons why we have all these protections for the accused, right? All these very strong and chartered rights and all that kind of stuff, and so specifically to that point, I mean, although a mid-sized company might not be able to hire Peter to go out and do his own CV study, for instance, they can hire Peter as an expert, just like they hire experts now. Just for instance, poke holes or essentially argue that the expert evidence introduced by the Crown is not reliable or should be diminished, should be reduced by a certain amount or something like that. So I don't think, I agree with you, they're not probably going to do their own. The Crown will go ahead and probably, if anyone's going to, the Crown will have the burden of doing this work. I don't know that it's such a powerful imbalance, because at the end of the day you can hire experts who will either validate or contradict, and that's the reality in this context. There's always competing expertise. Companies often find their own hydrologists, their own hydrogeologists, their own biologists to argue with whether the Department of Fisheries, Oceans, or whoever about the extent of harm, right? It's just that right now that discussion is being done at the biophysical level, and we're talking about bringing it into just a different area of expertise, which is socio-economic. And then on the second point, and I guess I want to say that I think at the same time, I think there's actually a good news story here for, and I'm going back to Sean's story, right, where Sean talked about, this prospective threat in the negotiation in Syncrude of like a maximum $100,000 fine multiplied against each bird, right, that brings you to some crazy number. Well, I think our response is, well, certainly these numbers can be high. I think it'd be very hard to convince a judge that there's any kind of study that shows that each migratory bird in North America is worth $100,000. So at the same time, you actually are starting to create, instead of making it incredibly sort of random, and sort of, and you actually might give certainty to industry that, okay, these are the tools and these are the methods that can be used to quantify this harm. Let's do that and use that in our cost benefit analysis when we go into the negotiation process. And then on the second point, and you can talk more about the value, but.
Okay, the second point's interesting. I've tried to get funding to actually look at something. For example, I wrote a long grant to Environment Canada, or to Agriculture Canada, sorry, to actually value ecosystem services coming from the Lake Winnipeg issue, which is one of the national water pollution issues in Canada. And I didn't get funded. That's not why I'm upset. What I'm upset about is that Environment Canada actually put out a contract for a bunch of consultants to collect data on that topic, and they couldn't find anything. I could have told them that, like, I know what's out there. So we've tried. The other thing you got to be aware of is, let's just take a wetland case. I'm trying right now to actually start a research program on valuing ecosystem services from wetlands. The problem is every wetland isn't the same. And if, when you take the definition of an ecosystem service, a wetland in the middle of nowhere in someone's field probably has 0 ecosystem services associated with it, because it's direct benefit to humans. Now, the owner of the farm might hunt ducks or something, so he gets a benefit. But the value of that's going to be incredibly small. And so when you tell this to scientists, they get really upset. But if you're going to use the concept, use it properly. And in that context, picking a stormwater retention pond is incredibly valuable. You can imagine the ecosystem services that come from that: property values, recreational trips, scenic amenities. They have a different suite of ecosystem services, but if you were to take and value them, they'd probably be a lot higher than a complex of wetlands in an agricultural area that does groundwater purification and provides wildlife habitat and all that kind of stuff. So understanding what the concept is really important. But I agree. I think we really need some empirical studies. But we've got to be aware that they're going to be different depending on where you do them and what the context or the status of the resource is or the ecosystem that you're looking at. I'd love to do stuff like that. We've been trying.
There are some, and I think we've talked about sort of the varying degree of rigor. There are some studies that have been done on the Lower Mainland in BC, for instance, trying to quantify the ecosystem services there. I think I alluded to one of them. But those are most.
That's the back of the envelope stuff. Yeah. And the back of the envelope stuff is dangerous in this area. That's where I have a really good friend, Mark Anielski, who comes up with these per hectare values. That's bunk. What you're telling me is that every hectare of boreal forest is the same. Like, imagine a pollution case where you're going to have, you ruin X number of hectares of critical boreal forest that's of critical value to the survival of, First Nations people and all this. That's way more valuable than this average over the entire thing, even if you believe in how you calculate the average. So I'm actually really worried that judges are going to take this this average value per hectare and starting to do that for sentencing. And in many cases, you're going to either grossly overvalue or grossly undervalue the asset that's affected by the damage, by the harm. So, that's another, I'm on a soapbox. That's the same problem, okay? So, hopefully that answered your question.
Yes, thank you.
Any other questions? Well, your timing's impeccable. We're just about 5 minutes left, which gives me a few minutes to say some thank yous. First of all, to the Marine and Environmental Law Institute and the Schulich School of Law here at Dalhousie University. And I think I can extend those thanks on behalf of my own institute, the Canadian Institute of Resources Law at the University of Calgary. I would like very much to reiterate my thanks to Environment Canada, who did not turn down our request for money. And they have been remarkably generous in funding this series of symposia. And for those of you who aren't aware of it, the 3 symposia in this series and the papers, all the materials are permanently on the website of the Canadian Institute of Resources Law. I think it's CIRL.ca. So you'll find both the papers in both official languages, and you'll also find a podcast of each symposium. Finally, I want to thank the speakers, especially those who have come some distance to be with us. February is the nicest time of year to be in Halifax. I'm sure that's one of the reasons you've come, but it's still quite a distance to come. And thank you for the work you've put into the papers. I think it's been incredibly informative, certainly has been for me, and I hope for our audience, especially our virtual audience out there on the web. So thank you all.